We'll get started with business and immigration law updates. This is a proud presentation of Mr. Ramesh Khurana, who is the Chief Attorney and Counselor at Immigration Law at the Khurana Law Firm in Gaithersburg, Maryland. On this set today, the moderator is Attorney Kenneth Haber from Boyd's, Maryland. Let's see these two attorneys in their exchange of words in their legal dialogue.
Welcome. This is the Capitol Forum. I'm Kenneth Haber, a former Assistant United States Attorney and a former Senior Attorney in the Office of Investigation. My practice is in healthcare law. I represent physicians. With me is an individual, Ramesh Khurana, who represents people across the world. Literally, he's an immigration attorney. He's a great immigration attorney, if you ask me, and I've known him for a number of years. And I've had him help me with my wife's immigration petitions.
I think now 15 years. We have known each other for the last 15 years. Yeah.
Yeah, because I was married to her 14 years ago.
Okay.
So at least 15. Well, we knew each other even before then.
Right.
Yeah, but in any event, he is one of the top-notch immigration attorneys, and he's here to answer questions that if you have any interest in immigration, you'll have interest in these. Thank you, Ramesh, for joining us.
Thank you, Ken. I really appreciate your very nice introduction.
Well,
you are always very kind on me.
It comes from my heart. We've known each other
for
a number of years.
I know that.
Could you please explain for the viewing audience the circumstances when an employer is required to file an amended petition to USCIS concerning H-1B visa application?
I'll be happy to do that, Ken, and my great pleasure.
Thank you.
Ken, the whole landscape about the filing of amendment petition changed in April of 2015 when the Administrative Appeals Office issued a precedent decision, which is matter of SIMIO Solution LLC. Now, under this decision, Administrative Appeals Office held that employers must file amended H-1B petition when a new labor condition application is required. Now, prior to this decision, now whenever there was a change in the work location, now there was a workaround. The employer would just file the labor condition application and he will continue to employ that employee. So, now they say if the work location changes and this is outside the Metropolitan Statistical Area, this is the key word. If the new work location is outside the Metropolitan Statistical Area, then the employer is required to file an amended petition because this amounts to a material change.
It certainly would if he, instead of Los Angeles, he's in Washington, D.C.
Right. So, the buzzword is the material change, and because otherwise this change affects the eligibility of H-1B status, and it is a material change for the purpose of 8 CFR sections 214.2 H2IE. So, I do not want to go into these numbers, but it then becomes basically a material change as defined in the CFR.
Would a person want to make this amended application, amended change, before they move the employee to make sure that they're going to be able to keep him on, or should they wait till he's there?
I like this question. This is very important. Sometimes employers do commit this mistake. As soon as the work location changes, they will ask their employee to move to the new work location. But it's a caution for the employers. You can't do that. If the work location has changed and this is outside the Metropolitan Statistical Area and there is a need to file another labor condition application, as we discussed under the Administrative Appeals Office unprecedented decision of 2015, you are required to file an amended petition. First of all, file the petition, and filing of the petition is evidence when the petition is received by the Department of Homeland Security. Once it is filed, then under AC 21, you can move the employee to a new work location. And nowadays especially it has become very important because now premium processing is stopped and decision cannot be obtained in about 15 calendar days. So, you have to wait for the adjudication of the petition, which may take 6 months, 9 months, who knows. So, wait for the filing of the petition.
If you file the petition and you then transfer the employee, and if the petition's denied, where are you at that point in time?
It may happen because there are no guarantees that the amended H-1B petition which has been filed now will be granted, because each petition is decided based on the merit of the petition as standalone. You cannot just claim that the petition for the same employer, same employee has been approved 2 times prior to this petition, so this should be approved. It's not approvable just based on this assumption. So, it can be denied. So, when it is denied, depending upon the facts of the case, then you have to review the decision of the USCIS and make a determination. Maybe at that point of time, if you think that you have no reasons to overcome the deficiency, of course, first of all, before it is denied, you get an RFE, request for further evidence. At the time of request for further evidence, you have another opportunity to make your strong arguments, whatever are available for the particular case. But if it is denied, of course, you can file an appeal with the Administrative Appeals Office, but simply filing an appeal does not give the valid status to the employee to continue to work. That employee has to cease to stop working the moment this denial notice comes. Then this person better goes outside the United States, and this person may have 60 days again. So, 60 days is the grace period as from January 17th of 2017, when you can file another H-1B petition. Maybe this particular employer, he chooses a different position for which this employee is eligible. This employer can file another petition for this employee, or if this employee is hired by another employer, that employer can file the petition. So, this 60-day grace period is really very useful for the employees who go out of status for whatever reasons, either they are terminated or they are laid off or their petitions get denied. So, they get another chance.
If the employer still has the old office, say back in California, and there's still a slot open there, they just thought he was going to be more productive in Washington, D.C. Could he go back to California and take the old slot that he had previously and continue working? Is that original application still valid then?
Okay, it depends. Again,
Everything.
let us say an amended petition is filed, but the employee has not yet moved to the new location. Work was still available for the old location. So, in that kind of situation, he can continue to work. In
What happens if he actually moved once it was filed?
If he has moved, then there is no coming back.
He can't come back.
No, he needs to file another petition.
He's really messed up.
Yeah, he needs to file another petition because he took the risk, because under AC 21 he moved to a new location just on filing of an amended petition. Now, once he has moved, he has severed his relationship with the previous petition. Now, he needs to file another petition within 60 days.
And that could be denied because of changing circumstances, theoretically.
Again, depends.
Depends.
But of course, this time employer and employee, probably both of them will be very careful in choosing the right type of position. So, otherwise, if the premium processing is there, we would recommend to the employee, okay, go out of the country. Let us say if nothing happens in 60 days, and then we will file the petition. You can return only on approval of H-1B petition. Now, let me tell you, Ken, there are other situations as well where you have to file an amended petition. Let us say the current petition which was approved by USCIS for the employee, this is for a full-time position. Now, the employer wants this employee just to work on a part-time basis. So, this is a material change. So, for this kind of situation, you need to file an amended petition. And likewise, if a person's petition is approved based on the part-time work, now you want that employee to work on a full-time basis, you again need to file an amended petition. Let us say if duties are changed from one specialty occupation to another specialty occupation. This is a different job code. In that kind of situation also it's a material change, so you need to file an amended petition. And even let's talk about in our general situation, companies are acquired or they are bought over by different companies, and so long as there is a successor company which is willing to take all the immigration responsibilities of this petition, then you do not need to file an amended petition. So, of course, we can keep on talking about the amended petitions forever, but these are some of the important concepts which people should know.
That's important.
Yeah.
Are there any H-1B time limitations for the beneficiary of an H-1B
Sure.
petition?
Essentially speaking, H-1B is available for a period of 6 years, unless that person qualifies for any exception. Now, in order to have further time, the person will have to reside for 1 year physically outside the United States. He can start the recycle of 6 years again. But there may be situations where the green card process by way of filing of labor condition certification request with the U.S. Department of Labor already started, and 365 days have already gone by, then you can file an extension for 1 year. And if I-140 petition has been approved, then you can keep on renewing H-1B in increments of 3 years. It's a kind of available for an indefinite period of time, so long as you continue to comply with certain conditions.
The H-1B persons, can they go back to their home countries and visit?
Oh, definitely. Definitely, they can go back to the home countries and visit, and there is an advantage of that in terms of time limitation of H-1B petition. As we said, the maximum period allowed under H-1B status is 6 years, unless that person qualifies for some exceptions. We talked about the exceptions. Now, this is another situation where the person can have his status extended. Now, let us say that person stayed outside the United States, physical stay for 6 months in India. So, that physical stay outside the United States, now that person can recapture. So, sometimes even this small period I have seen, even 1 month period, that comes very handy. If 1 month is left, so you can file for 1 month, and maybe you have started the green card process by way of filing the labor certification already, but labor is not yet certified, or 365 days have not gone by. So, those 6 months or whatever period is left out, which we are trying to recapture here, that becomes very handy, my dear friend. So, this is something when we do intake exercise for an H-1B employee. So, we have a questionnaire, and we will ask all these questions from the employee. Did you physically stay outside the United States? Give us the dates. When did you leave the United States? When did you return? What are the countries visited? Give us the evidence in terms of your I-94s or dates which are placed in the passport. So, those details are very helpful.
Wouldn't that all be contained in the passport normally?
Sometimes they will put the date. When you leave the United States, there are no dates.
Oh, really?
Yeah. But when you return, you meet with the CBP, they put the date in the passport. But sometimes when you come back. So, unfortunately, sometimes these dates are not legible. Then you have to go for online record to see what is the departure and arrival record of that foreign national. Sometimes you don't find even electronic records. Then you try to see maybe this person is having itineraries of air travel. So, we ask for the copies of itineraries. So, we have different ways depending upon the situation.
And so, if they're using some sort of company for their travel,
Right.
Their documents would be evidence.
Yes, and along with boarding passes and some other evidence. Let us say a person visited India. So, probably the Immigration Bureau in India would have put some anti-stamp in the passport. So that could also be given as a supporting evidence.
Very good.
Yeah.
Very good. Well, I'd like to thank you very much for coming on in and sharing this information with our viewing audience. And I'd like to thank the viewing audience for being here and watching us. And thank you very much.
Always a great pleasure, Ken.
My pleasure.
Always a great pleasure. Thank you very much for inviting me.
Thank you.